Good morning. Let us kick off this session. I would apologize on behalf of our organizers because we have some issues. We have experienced certain issues. That's why among the claimed speakers, announced speakers rather, due to certain variety of reasons, we have only 3 members of the panel. We would do our best to use the time allotted to us to review in great details various aspects of relations between Russia and the European Union, and also between the customs union, EurAsEC, and the European Union as well. My name is Nikolai Mizulin. I'm a partner of the legal firm Meyer Brown, work in Brussels and Moscow. I specialize on issues of protecting Russian interests of Russian business in the European Union, and vice versa, assisting international companies in their business in Russia and the customs union. Among our panelists today, we have the pleasure of Michel Laurent, who works in the Secretariat of the Commissioner of European Union on Justice. He will highlight issues relating to cooperation and interaction between the Russian Federation and the European Union in areas dealing with the transportation of physical persons, immigration policies, visa policies, and also he will address issues relating to those events which have occurred recently in the European Union relative to justice issues or assistance in addressing legal cases and immigration visa policies. To my right is a professor of Stockholm University, Mr. Mohamed Saad. He will be dealing with the history of integration in the European continent. He will address the issue of formation of the uniform or united European market, and those lessons which we, as the current builders of the integration formation in the post-Soviet space, in the shape of the customs union of Russia, between Russia, Kazakhstan, and Belarus, we can withdraw. I will highlight issues of trade and economic cooperation between the Russian Federation and the European Union, customs unions, and Europe, and we will look at the possible ways of development of such relations, and we'll touch the issue of possible formation of the free zone trade between the 2 formations. With your permission, we will kick off this meeting by giving the floor to Mr. Laurent. You have the floor, sir.
Well, hello everybody. It's nice to be here. I will speak in English. Sorry, my Russian is too limited. In fact, I will draw your attention on the new legal development in the field of justice and home affairs. In the EU, we have the new Lisbon Treaty. It entered into force 2.5 years ago, and it has completely changed the legal framework within the European Union in the field of justice and home affairs. There are 4 main changes with the Lisbon Treaty. First, it abolished the former so-called pillar structure. Second, it extends the competence of the European Court of Justice, which was before prevented to deal with criminal law cases. Third, it strengthened the democratic legitimacy of the process because the European Parliament now has as much as power as the Council to adopt legislation. That's what we call co-decision. And finally, we have extended the voting through what we call qualified majority, which means that we don't need unanimity of member states now to adopt legislation in the field of criminal law, in the field of justice and home affairs, which make it far more easier to adopt legislation more quickly, and also we don't need to make compromise too much to have the legislation to be adopted, so we don't adopt legislation with lower common denominator anymore. So I will try to describe what has happened over the last 2 years and a half and what is in the pipeline in this field. First, with migration, asylum, and visa issue, and then we'll deal with more the security per se issues. So in the field of migration, there is economic crisis. So people believe that we don't need migrants anymore. But like in Russia, we have a demographic problem. And by 2050, we assess that we will need 50 million more people as workers into Europe. So we need more migrants. And for that, we need to have a proper legal framework. And this is very important. And we have started to adopt European Union migration policy by adopting legislation like the Single Permit Directive, which accelerates administrative procedure for legal migration. We have adopted what we call the Blue Card, which is focused on high-skilled workers who want to migrate to the EU. And also in the pipeline, so when I'm saying in the pipeline, it means that the European Commission has put forward a proposal, and now it has to be adopted by the European Parliament and the Council. We have two important legislation, one on intra-corporate transferees, which are people who are working in international companies and who want to work within Europe, so we want to facilitate the transfer of these people within the EU. And second, a proposal on low-skilled workers, what we call seasonal workers, who are coming to Europe just for a season to work in the tourist industry or in the agriculture sector. And here, again, we want to facilitate this. But of course, we need also to deal with irregular migration. European migration policy means that we choose who we want to migrate, and we are not imposed by migration flows. And so we are trying to increase our power in the field of fighting irregular migration. We have adopted last year a legislation setting up a reinforced agency to fight against irregular migration, what we call the Frontex agency. We have adopted legislation also on employment, on employers who employ irregularly some irregular migrants, and so we have sanctions against these employers, heavy sanctions, and so on. Another piece of legislation which is in the process of being finalized is our new EU asylum system. So the head of states and government of the 27 member states of the EU have asked the Commission to put forward a new package of legislation in the field of asylum, and they have asked us to have this legislation be adopted by the end of the year. And so we have different types of legislation on the qualification of the beneficiary of international protection, on the reception conditions of asylum seekers, and so on the responsibility of the member states, how to share the responsibility when asylum seekers are coming, who is responsible for what, and so on. This legislation is in the process of being adopted, and we'll have a real common asylum system in Europe. You have to take into account that, for instance, an Afghani or Somali, when he arrives and asks for asylum in Europe, he has 10 times less chance to get asylum if he asks asylum in Greece or if he asks asylum in Sweden. So there's a lot of discrepancy, and we'll try to harmonize that. This is very important if we want to have the Schengen area work properly. If we want to have the free movement of the people within Schengen, we need proper border control, we need proper asylum system in all the member states. And we have also, last September, adopted a new legislation package on Schengen, how to manage the Schengen area, because also there are some problems with some member states who are not controlling properly their external borders. And so we'll have the possibility with the new rules to reinstore borders with one of the member states if these member states are serious deficiency in the control of its external borders. It's in order to avoid that a lot of irregular migrants are coming with these countries and then are within the Schengen area circulating freely. Of course, migration means also a proper relationship with our partners, in particular key transit countries. And Turkey is one of the big transit countries for irregular migrants. 80% of the irregular migrants coming to Europe are crossing via Turkey right now. And of course, also with countries of origin like Russia, and we have an important dialogue on migration with Russia that we have launched last year with Minister Konovalov and at our regular ministerial meeting in the field of justice and home affairs between the EU and Russia. And in that context, I just want to mention two elements. One is local border traffic. We have adopted this year a new amended proposal on legislation on local border traffic to deal with Kaliningrad to facilitate the movement of people, of the citizens of Kaliningrad. And also we have a dialogue, visa dialogue with Russia, which is quite important. What we call it the common steps, and we are in the process of developing this dialogue, which have some conditions before we go to the full visa waiver. That means full visa liberalization between the EU and Russia. In the meantime, until we have this visa waiver, we try to facilitate the life of the Russian and EU citizens when they are traveling to each other. And we have enforced a visa facilitation agreement, which is currently being renegotiated to improve it further, to facilitate both Russian coming to Europe and European coming to Russia. We know it's a complex process. We receive a lot of complaints. People are not always happy, and European citizens are not always happy when they try to get a visa to go to Russia and vice versa. But we are trying to improve the situation. We have also a readmission agreement with Russia, which is also very important, which is when an irregular Russian migrant is in Europe, there is a process to send him back to Russia, and we need to do it according to proper rules and respecting his fundamental rights and so on. So there is a readmission agreement between the EU and Russia, which is working quite well. So this is for the migration and the visa part. On the security policy, we have also had over the last 2 years a lot of legal development in the field of security. A number of legislation has been adopted. Legislation against sexual exploitation of children was adopted last year with very high level of prosecution and better protection of the victims. We have also a new directive on the trafficking in human beings, again focusing on prevention, prosecution and protection. In addition, we are working also in the field of drugs with also a new criminal law for drug trafficking. And at international level, it's worth noting that we have we have reached an agreement on drug precursors with Russia, which is an important legislation to fight drug precursors. In the field of terrorism, also we have been active. It's also a completely new area at the level of the EU. Before, the member states thought that the fight against terrorism was really their own competence, but now more and more the EU is being active in the fight against terrorism. We have signed 2 international agreements with the United States, one on the terrorist financing tracking program, which help us to find terrorists through banking transfers, money transfers, and it's a very important piece of legislation. We have already had some very good results catching terrorists just with the money tracks. The other piece of international agreement that we have signed with the Americans recently, a month ago, was on EU-United States passenger name record agreement, which is the data of the passenger when they are traveling between the EU and the United States. We have also signed such an agreement with Australia. We are negotiating with Canada and a few other countries in that field. Also in the field of criminal law, we have put forward 2 months ago an important piece of legislation on the confiscation of assets and the recovery of criminal assets. This is a very important legislation which raises a lot of legal issue because we want to be able to freeze and confiscate assets of criminals even before they have been convicted. So when all the guarantees are there, we could seize the assets of criminals before they are convicted. And it raised a lot of legal and constitutional issues with some member states, so the legislation now is in the process of being adopted in the Parliament and in the Council. As you can see, we have developed legislation over the last 2 years and a half in all the components of security, from terrorism to drugs to child abduction and so on. In the field of legal proceedings, we have also been working on common minimum standards, and in fact we have put forward 5 legislative measures. The right to interpretation and translation, and it matters because in fact more and more European citizens are traveling and working and living in different member states, so they need to have the right of interpretation and translation during trials. They need to have the right to proper access to information, even if they are foreigners. They need the right of legal advice, free legal advice when necessary, even as foreigners. And they have the right for communicating with family members, consular authorities, and so on. And 5, the protection of vulnerable victims. We've got specific legislation on that. And these are common minimum standards. So we are improving the rule of law in all the EU 27 member states by setting up common minimum standards. So these are also important developments. And as you can see, and that would be my conclusion for now, since the Lisbon Treaty, in 2 years and a half, we have really developed tremendously our legislation in all fields. And, you know, a lot of people are describing Europe as a weak system, and Europe in crisis. It's always the headline, Europe is in crisis, the euro in crisis, and so on. But I think that historians, when they will take distance with what has been achieved recently in this field, I think they will pay tribute to what has been done. And I mean, we have changed completely the legal framework in the field of justice and home affairs over the last 2 years, and we will continue to do so. And I can draw the parallel with what has been achieved recently in Russia with the legal system. There have been a lot of changes, and maybe a lot of criticism on the Russia system is seen in the media because there are some problems, and still some heavy problems. But there have been a lot of positive development as well. And so what we are asking is just a fair assessment of what has been achieved, both in Russia and in the EU. Thank you, and spasiba za vнимание.
Thank you for your attention.
Thank you very much for a very interesting and very concise presentation. I would like to open the floor for questions. If no one has, I can start, in fact, with a couple of questions that appeared in my head while you were talking. One, and the one which is on the surface, is about the status of negotiations between Russia and the EU on the visa waiver. Which obstacles are out there, and what Russia, in fact, has to do in order to achieve progress in those negotiations, from your point of view. And the second question has to do with the topic you raised on on the freeze of assets and confiscation. We are most likely, Russia will have a major problem with the United States, probably later this summer with the Magnitsky bill, which will be adopted as a quid pro quo for the granting of Russia permanent normal trade relations, basically the MFN treatment which is required for the WTO accession. Is something like that in the pipeline in the European Union, or what's the status of the discussions in the Parliament, to the extent you know, obviously?
Yes. First of all, on the visa process, as I said, we have already a visa facilitation agreement with Russia, and last year we issued 5.6 million visas to Russian citizens just last year. And we are trying to have it as smooth as possible, the deliverance of visa. We are now trying to harmonize as much as we can the documents which are required to get a visa, to limit the number of documents we requested for Russian citizens. And we have instructed our consular services to issue as much as possible multiple entry visa, so that you go only once and then you have a multiple entry visa for 3, 4, up to 5 years for now on. So that will facilitate life of Russian citizens. Well, to compare between EU and the United States, because you made in your second question, with the United States only issued 220,000 visas last year, while we issued 5.6 million. So there's a big difference. But of course, the ultimate goal is to abolish completely the visa, and there are some risks. There are some migration risk, and there are some security risk as well, and by doing so. So member states, the EU member states, are not completely at ease with a visa waiver with Russia. It's a big step forward. And we have set up what we call the common steps, and we have started the dialogue just last year. It will take some time. There are some preconditions in terms of rule of law, in terms of security of documents. We require, for instance, that all the Russian citizens who will benefit from the visa waiver will have to have a biometric passport and a secure biometric passport and so on, in order to limit the risk in terms of security and in terms of also irregular migration. Data protection is a big issue in different fields. We also request that there is independent data protection, fully independent data protection authority in Russia. It's a precondition for an agreement that we are waiting to sign with Russia in police cooperation, an agreement with Europol, the European Police Office, and this is also a precondition for the visa waiver agreement. So there are a lot of conditions in these common steps. We are making progress, but we are not there yet. It will take a bit more time. On your question related to the Magnitsky case, I think it's not only the United States who are worried with the issue with in the case of Magnitsky death. Magnitsky was beaten to death in jail, and after denouncing a big corruption case in Russia, the only person so far convicted is one doctor in the jail, and we consider that it is far from enough. There was an independent committee, Russian committee, who have shown that he was beaten to death, and that and the process, the due process, is not sufficiently advancing according to the European Union as well. And it's not only the United States who are worried about it. Herman Van Rompuy, who is the president of the European Council, wrote to President Medvedev at the time, like a couple of weeks ago, raising the case as well. This is becoming an emblematic case, a symbolic case, this Magnitsky case, and it's a pity because everybody identifies the rule of law now in the media with this Magnitsky case. So we are calling the Russian authorities to proceed quickly with this case. We are also appalled by the fact that now Mr. Magnitsky will be subject to a trial, a new trial, while he's dead. And I mean, it's contrary to all the Council of Europe rules, and Russia is a member of the Council of Europe. We do not go for trial with someone who cannot defend himself, because the person is dead. And so we are also raising it at every level when we meet the Russian authorities, be it with Mr. Konovalov, with the President in the coming summit. It will be also an issue. But we are not making a link between this case and the visa issue, or we are not making a link between this case and WTO accession of Russia. We want to deal it bilaterally according to, and not making kind of bargaining or taking hostage one file with another. But we are very worried, and we really hope that the Russian authorities will do their best to solve this case. Thank you.
Большое спасибо. Еще вопросы?
Thank you very much. Any other questions? Good afternoon. My name is Elena Filimonova. I work at the Ministry of Justice, Belarus. I head the International Law Department. And a question to Mr. Lavrana, I would like to clarify that what, according to you, could be perspectives of cooperation in struggling against criminals, so that Belarus could enter conventions on legal assistance on criminal cases, and what would be the impact? What would be the impact on the struggle against criminals, and what instruments could be used in order to implement this most successful cooperation in this field?
Yeah, it's a very complex question. In fact, there are a lot of conditions which are attached to that. We, of course, have cooperation in the field of criminal law with Russia, but in the field of extradition, in the field of mutual legal assistance, we are less advanced, for instance, than with the United States, where we have EU United States agreement in the field of extradition and mutual legal assistance. And why is that? It's because we believe that the rule of law in Russia is not sufficiently developed at this stage to have this type of agreement. Because when you send back from Europe a presumed criminal to be tried in Russia, we need to have sufficient guarantee that he will have a fair trial. And this is one of the issues that we just discussed with the Magnitsky case. We need to have guarantees that he will be subject to a sufficiently fair trial. And that is why it is important that the Russian government show that the rule of law is completely according to European standard, according to international standard, before we can sign this type of agreement. But of course, there is bilateral cooperation at the level of member states, and on case-by-case basis, we do it. And there are extradition process. They are sometimes very slow, and we will try to improve that. But to have an overall umbrella agreement on that, it will take a bit more time. But we are aiming at that, and it will be a good way to improve our cooperation. And as I said, we are about to sign an agreement between Russia and our police office, Europol, and there will be Russian officer posted in Europol, and vice versa. So we are making a lot of progress, but the ultimate goal of an extradition mechanism which will be quick and efficient will still take time. And also you have to understand that some of the criminals who are requested to go back to Russia have asked asylum into Europe, and they are protected by our asylum law. So they benefit from asylum, and they cannot be extradited that easily to Russia before proper investigation by European authorities. Thank you.
Будут ли еще вопросы?
Any other questions? With your permission, I would ask another question, once again referring to the subject of Belarus. I mean, economic sanctions against Belarus and the rest, and the freezing of assets of the officials in Belarus. I wonder at what stage is this work, and whether we should expect further sanctions. And I'd like to know your opinion whether we have to expect further sanctions against Belarusian companies. I wonder whether the list of Belarusian companies be expanded. Well, we have joint interests a bit with the Belarusian companies. I don't know whether this issue is in your competence. Well, I think that it could be referred to the Directorate on Foreign Relations, but probably you can make some comments on this issue. Thank you.
Yes, this is on the Lady Ashton competence, not the Commissioner Malmström competence, so it's more foreign affairs than home affairs. But of course, we work together. And I cannot comment on the next round of sanctions. It will really depend on Mr. Lukashenko and what he's going to do next. And so I think we are trying to keep a balanced approach. And my only comment is on the efficiency of these sanctions. I've seen that there have been some counterproductive impacts of for instance, of the fact of being on the list or not on the list of the personality, because it seemed that some Belarusians were complaining not to be on the list of the people to be banned of entry into the EU, because when you were on the list, you were close to the president of Belarus. And if you were not on the list, you might be considered as maybe a friend of the West, and so for some Belarusians it was better to be on the list than not on the list. So you can have some counterproductive impact on this type of measure, and so you have to be careful with sanctions. We see it also with Iran. Some are working better than others, but of course, if you want to be effective in terms of sanction and in terms of companies to be sanctioned, of course, if you look at the business in Belarus, if you target the energy sector, the refineries, pipeline, and so on, then you will have a big impact. But it's up to, but it will also impact Europe as well, because we're importing from Belarus. So it's some things which are being discussed internally. But there's no easy answer.
Alimbekov, зампред суда EurAsEC.
Alimbekov, Deputy Chair of the Judge in EurAsEC. How do you compile this list, blacklist, and what are the limitations from the point of view of law? So it should be, first of all, ruled by the court, or is it only ruled by political circles or political authorities, and the court has nothing to do with it? I wonder these limitations as to the transferees of the citizens who were included into this blacklist, not according to the ruling of the court, but according to the decision taken by the political authorities. And how could it be explained from the point of view of political freedoms? For instance, I wonder whether there were any trials where the court would check the validity of these measures, whether they are fully adequate to the existing law, or do they contradict the existing law?
No, in fact, it's a political decision when we take sanctions. So there's no judicial process in that. And it could be criticized, of course, but there's no judicial review before we take this decision to put someone on the visa ban list. And this is only for sanctions vis-à-vis a state. When we put visa ban on Schengen area on a normal daily basis for criminals, here, it's a member state. We introduced the visa ban, and it goes for all the border controls. And this is done once you have a prosecution system in place. So you have someone who is prosecuted, a criminal which is looked after, searched, and here, in that case, there is a judicial process. But for the sanctions vis-à-vis Belarus or vis-à-vis Iran and so on, there is no such judicial process. It's a political or diplomatic decision. We identify the key political figures. We identify the key companies where it will have the most economic impact, because we want to have the economic sanction as efficient as possible. So no judicial process, but sometimes you can have a court proceeding based on that decision. So a company can go to the court and complain why they are on the list, and they can seek for compensation. That has already happened.
Microphone, please. A judge of the International Court, but I represent the Republic of Belarus. Well, the question was asked like this: prohibition for the entry of the countries close to us. Well, that was mainly according to the cases analyzed by the court, and they were guided by the national legislation. But at the same time, they apply those sanctions which concern rights and freedoms of concrete citizens. And therefore, I would try to draw the parallel between their rights to visiting countries and the commitments which they have according to or in connection with their professional duties. They are judges of the International Court, but from the Republic of Belarus, and they should carry out international activity, and they have international immunity, and they have the status according to the Vienna Convention of diplomatic immunities of international officials, and they are included into the national list, and they are deprived of all this without trial. This is direct violation of international law. Ну, опять же, я хочу повторить, что, естественно, можно обратиться в Международный суд. И, естественно, я еще раз повторяю, что это было политическое решение, которое было принято.
Translation is working? Okay. Yes. Okay. This is really an area specific which is outside the justice and home affairs issue that I was discussing before. It's really a foreign policy instrument. And vis-à-vis Belarus, what we have done is to have visa facilitation for the normal citizen. So we are trying to increase the visa facilitation for the normal citizen, but not for some key people who are put on the list and banned of entry into the EU. And on the visa facilitation, we have a mandate, the European Commission, so my services have a mandate to negotiate with Belarus the facilitation of issuance of visa for normal citizens, for NGOs, for students, for researchers, and so on. So we want to facilitate the normal life of the citizen, but not of the political elite. And that's what has been decided at European level. For the time being, the Belarus government has refused to enter into negotiation with us on a visa facilitation agreement for the normal citizens. And so we want to help the normal citizen, but not the political authority in Belarus. That's the position of the EU. Thank you.
Я прошу прощения. Или же не совсем вы понимаете...
Well, you probably do not understand the question correctly. It might be the case. Or maybe the interpreters are absolutely wrong in this particular case. Well, judges throughout the world, according to all international treaties, the main principle of the jurisprudence is the independence of a judge, and nobody rejects it. But in this particular case, the judges that ruled their decisions, and these political sanctions were taken against those persons. But it means that according to a certain body, a certain authority, any decision of any judge of any state may be recognized as politically inexpedient. And on this basis, the judge may be limited in his rights. Doesn't it seem to you that it contradicts the basic international principles? Thank you. Well, political relations between the states should not touch upon the principles of independence of a judge. Thank you.
Well, as I said, I think I understood your point of view, but I don't want to comment too much on the independence of justice in Belarus. And this was a decision which has been taken by unanimity by the 27 member states of the European Union. And of course, if there are some specific cases where you believe that these people should not be on the list, well, you can always write and explain to us why, and we are ready to reconsider some of the names on the list.
Если позволите,
if you allow me, well, we are discussing now very delicate issues in connection. You know, Mr. Loran is in the European Commission, in the executive body, and he emphasized that there was not a decision taken by him, but by the representatives of law. Well, he said that it was a political decision, and a political decision, I, as a free, I mean, from a point of view of free comment, may say that of political realities and of the policy that is pursued by the European Union. In this, it was expedient to infringe this principle and introduce international sanctions despite the agreements that exist. With your permission, Mr. Mohammed, I also wanted to comment on it. Большое спасибо. Я хотел бы также прокомментировать этот вопрос по поводу санкций против Белоруссии.
The judge from the European EurAsEC court, that's a very interesting issue. As my colleague said, it's a political decision. It has to be done unanimously, decided by the Council. But actually, this has to be translated into a legal act, which is called the Council regulation. Now, this regulation could be subject to judicial review before the European Court of Justice. And there was a very interesting case where the European Union imposed a sanction on a particular organization relating to terrorism. Its case is called the Cadiz case. There was also a sanction from the Security Council decided and that was also there, the sanction. The people who were affected by this sanction, they went to the Court of Justice, and the Court of Justice said this regulation is invalid because the person who were affected by this regulation was not given an opportunity to be heard. So they said there's a serious breach of the natural justice, and that regulation was set aside by the European Court of Justice. And I don't think there is any kind of a barrier, even this regulation against Belarus identifying individuals. Maybe that could also be challenged, or at least Court of Justice should accept cases to review these kind of things, because a political decision, once it comes into a legal framework, that should be subject to strict judicial review. That's my personal view on this.
Thank you very much. I would like to add that, in fact, in Belarusian companies, some natural persons use this option, and in fact, they come out against the list, their names on the blacklist. Well, in fact, the court should analyze these cases from the point of view of colleagues. I would like to make a short comment. The matter is that the judges are prohibited to appeal to the International Court. Even Strasbourg took the first decision on the national judge, but it is considered that the judge of an international court should not be involved in any disputes, and therefore an acting judge cannot appeal to the international court. We are the same court as the Luxembourg court, and we have the task of cooperation. What do you suggest? That the judge of an equal international court appeal to the international court and ask the international court to protect him? Well, this is a very interesting international legal collision, and it should be discussed as a separate subject, because here are certain delicate things that were not taken into account and nobody thought about it. A judge that will have to cancel the decisions of the European Commission should control this decision on our territory, including the agreements that will be entered together with the European Union. We are included to the list of persons deprived of immunity, and we have to do everything so that the cooperation between the European Union and the EurAsEC should be impeded. And it seems to me that for us, well, it's absolutely logical to appeal to the court, and we have to address this problem from a scientific point of view, because we have to understand, first of all, there are certain immunities that you cannot infringe upon, and then we, for instance, want to see how shall we work together with Luxembourg. Two Belarusian judges were included into the list, and and they will say that this decision was ruled by the court. They didn't have the right to cooperate. We either cooperate or we raise problems between each other. Let's first of all analyze the situation with judges.
Эту тему вынес в отдельное обсуждение, может быть, на следующем уже юридическом форуме. Тема интересная, но опять же, единственное, хотел подчеркнуть сразу же, когда этот вопрос задавал, и здесь несправедливо задавать все эти вопросы господину Лорану, потому что действительно не в его компетенции. Не в его компетенции.
It would be unfair to ask Mr. Aran to post to him his question. This is not his cup of tea to answer this issue. Let us now discuss the, here the next presentation, which is to be made by Mr. Mohammed Said. He will be dealing with the history of integration of the European Union, creation of the single market area, and those lessons which we can draw from that process, and definitely will be interested to learn of possible mistakes which we can make and which we should avoid while in the process of building the integration formation between Russia, Belarus, and Kazakhstan. You have the floor, sir.
Thank you very much. I'm an academic, so I'm not in a very hot seat as my colleague here. As an academic, I'm very much free to discuss all the issues. And also, thank you very much, the chairman. And also, I wish to take this opportunity to thank the Petersburg Legal Forum for inviting me for the second year to be here. I'm actually not a stranger to these to St. Petersburg or Belarus. I'm teaching here. I come very often to the St. Petersburg State University. In Belarus, I teach at the Novopolotsk University. We have a lot of issues we discuss, even the question of this regulation against the EU regulation. We have a very interesting open discussion. So from an academic perspective, it's extremely interesting. Now, my short presentation here is to briefly explain how the European Union has developed and to what extent this model could be adaptable or followed in other regional organizations. Especially what we are going to talk about is the Eurasian Economic Community. In fact, I was teaching last week in Kazakhstan, so I have been discussing quite a lot about this Eurasian Economic Community. There's quite a lot of positive response from the students to have a very close relationship with Russia and Belarus and Kazakhstan. They want to develop more, I think, with Kyrgyzstan and other Central Asian region. Now, I want to highlight about the developments in the European Union. Now, the European Union succeeded. It started, as most of you know, in 1958, and the customs union was successfully completed by 1970. So during this period, there was hardly any kind of a tension between the member countries because it's very much of an economic cooperation. And then we come to what is called the second stage of the European integration, that is the single market. Now, in 1993, the European Union also launched very successfully the so-called single market in 4 economic freedoms. That is the free movement of goods, free movement of workers, free movement of services, free movement of capital. Now, then we come to the third stage of the European integration, and this has created a lot of problems internally within the European Union, and also the concerns which was expressed now about the problems with EU and Belarus. Now, until 1993, the main focus of the European Union was economic cooperation, economic integration. And EU had very healthy international trade relations with all over the world. Now, after the Maastricht Treaty, 1993, the European community got into 2 divisions. One is the European community, which was dealing with the single market, which the Eurasian Economic Community is now developing. And the second part is the European Union, which came with this idea of a common foreign policy and then justice and home affairs. Now here, since Maastricht Treaty, we have quite a lot of difficulties within the Union, because Union became Union within the Union. For example, the monetary union that came out after the Maastricht Treaty, there were some countries like United Kingdom, Denmark, they didn't want to participate in this program. Now, even in Sweden, of course, there is a kind of legal obligation, but just 10 to 15% of the Swedish voters want to adopt the euro. And then the same problem with the foreign and security policy area. Now, this really created quite a lot of tensions. I think I don't have to follow these slides. I can just give a brief overview. Now, I think European Union has come to a stage now where the process is irreversible. Now they are discussing about having a fiscal union, because all of us know about the fiscal crisis now in Greece, in It's spreading across the European Union countries. So what we have is the European Union is having the competence in the monetary policy. Now they are discussing that the fiscal policy should also be subject to the European Union competence. So if EU succeeds, or at least some of the member states succeed, I think there will be further, it will be a step towards a federation. Now this model, what European Union is having is something which was developed over a long period of time, 1958, and now it's more than 50 years. So it was a slow process. Now I don't say that what is happening after Maastricht Treaty is wrong, but it created a lot of more tensions than what it was before the Maastricht Treaty. Now this is something which Eurasian Economic Community could learn from the EU process. Now the single market, now I have, as I said before, I have been to some of these Eurasian countries. There is a free movement of goods. Now when I came to Pulkovo Airport, there was a fast-track procedure for people from Kazakhstan, Belarus, without any kind of borders. It works very well. So beyond that, if Eurasian Economic Community, there was also a suggestion by President of Kazakhstan that there should be a kind of a single currency for the Eurasian Economic Community. Again, I think the authorities have to be very careful to go into this kind of far-reaching policy decision. Of course, it's good because Eurasian Economic Community could work very well if there is sufficient monetary cooperation between the member countries. European Union had that before the introduction of the euro. They had a very close monetary cooperation without a single currency. We had what is called the European monetary system, where the countries cooperate each other without having a common policy. So I think this model could be very useful, I think, personally. That's my view, that Eurasian Economic Community can have close cooperation even in the field of monetary policy area, but not to subject them to a common monetary policy as what is happening in the European Union. Because the current problem we have at the European Union, the fiscal crisis, is some of the big mistakes that was done by the politicians. Now, some of the countries which joined the monetary union, from a legal perspective, from my interpretation, they don't qualify to be members of this monetary union. So once a political hard decision is taken on this issue, the result is what we could see with this fiscal crisis. So now these are some areas, I think, Eurasian Economic Community. I come from Sri Lanka. We also have a community called the South Asian Economic Regional Cooperation. Even the leaders from India, Pakistan, Sri Lanka, they are talking about a currency union. And I teach, for example, in Delhi at the Jawaharlal Nehru University. I have highlighted these problems. So they have to really be very careful before they make this kind of far-reaching decision. As far as the cooperation between the European Union and Euro-Asian Economic Community is concerned, I like to quote what President Putin once said. He would like to have an economic kind of a zone from Vladivostok till Lisbon. Now, I strongly support this view because the idea of this regional organization is not to build a fortress Europe or a fortress Euro-Asian Economic Community. It should be a building block to link the whole global organizations together. So in this context, I think Eurasian Economic Community and the European Union, they should at least go towards a kind of a free trade agreement. And as my colleague said, there is a lot of work going on to develop a kind of a visa system to remove the barriers. Now here, when it comes to free movement of goods, free movement of services, I think there shouldn't be any major obstacles between these two blocks. Already, free movement of capital is liberalized between these two blocks. I would like to highlight that the European Union legal system, it is extremely liberal when it comes to the financial services. European Union have 4 economic freedoms: free movement of goods, persons, services, and capital. Now, the last freedom is, I call it as a global freedom, because under the Lisbon Treaty, it says that everybody have the right to move the money, capital, not only within the 27 countries, but globally. So here we see that there is a lot of financial movements between the EU and countries like Russia and Kazakhstan, etc. Then when it comes to the free movement of workers, it's a bit of a difficult area for these two, because even within the European Union, this is one of the areas where we have less movement of workers between the member states. Even though the treaty says that there are a lot of soft barriers, language barriers, linguistic barriers, cultural barriers. So this free movement of workers is not really working optimum. And so if this is to be done between two regional organizations, it will be even more difficult. But when it comes to free movement of tourism, under the European law, it does not come under the free movement of workers, it comes under the free movement of services. Now here, the European Court of Justice has interpreted very broadly what constitutes services. Here the court says it's not only to provide services, but also to receive services. And according to the court, this tourism, medical services, legal profession, they are all services. So here EU and Eurasian Economic Community can develop quite a lot in the field of tourism. EU should be able to open the borders for tourists coming from this organization. Eurasian Economic Community should also open its borders to the 27 countries, because I have a lot of friends across the European Union. They love to travel to these countries, but again, because of this, the visa problem, it's very difficult. But with Russia, I think especially to St. Petersburg, now I'm based in Stockholm, they have simplified the visa system. You can come here, I think, 3 to 5 days or something like that without visa. So this, I think, should be extended, I think, to the Eurasian Economic Community. So this is my very brief comments, and so I'm open for further discussion in these two relations between these two great organizations. Thank you.
Thank you very much indeed, Ms. Said. Any questions from the floor? Sure. Why want to take a microphone? Нет, не работает. Well, it doesn't work. Thank you. You can hear me. I'm Marina from Köln University, researcher. I would like to comment the situation within the European Union relating to the now common policy in respect of the foreign investment. This is a new competency under the Lisbon Treaty. I know that there was a dispute between the member state of the EU and the European Commission. It was a discussion, rather, what to do with those bilateral investment treaties which are already in place between member states with for other states. What to do with those bilateral relations to be made between the country members. But we do need integration, but the member states want to retain their individual competence on those issues. If you have ability to comment the topical, the current situation, have you already arrived at some decision, or is it still pending? I would like to comment. I think I am competent enough. As you have mentioned, under the Lisbon Treaty, the competence of EU now also covers investments, as you know, to initiatives. Initiatives were proposed in investment policy for the future as to how EU would be negotiating, how agreements would be signed, what the content of those agreements could be, and then a schedule was introduced as for the to bilateral investment agreements which are already in place and which apply to the bilateral level by country members of EU. As you know, initially an idea was developed and put in motion as to analyze, and so to all the existing treaties should be analyzed to check the compatibility with the current legislation of EU, and the European Commission would retain the right to propose a cure of inconsistencies on the bilateral level. So the European Commission should issue directives or instructions to start negotiations and to remedy those inconsistencies if such inconsistencies are found in the treaties. That was related to certain number of court cases where the European Commission appealed to the EU court relating to against Austria, Sweden, if I'm not mistaken, in respect of bilateral relations with Russia, by the way, about the investment procedures, when some of the elements of those treaties were not in compliance with the freedom of movement of capital within the EU. And that court, if I am not wrong, was inconsistent, and that such inconsistency should be removed. But coming back to the draft schedule where this initiative was reflected, it was met rather unfavorably both by the business community and the key member state of the EU, because if anything in the EU is done well, a lot is done well, but if something is done well, but this is at least bilateral say agreement on investment protections, in particular those which were signed by Germany over the period of more than 50 years already, by by the UK, and there was no willingness on large key countries or investments in business which are using this investment protection agreement across the globe actually to review those agreements, which on a practical plane would result in lesser say protection of the investments in those countries where they have made such investments. So right now this schedule, this regulation as to what we will do with our legacy is still reviewed under consideration, and more probable is that the consensus which is likely to be found at the end of the day. And there was another idea to, say, define a date, a deadline, so that 20 years from now, all the bilateral relations should be reformatted to be compatible with the EU law. So that was all not accepted either. And as a result, this proposal will not be accepted. And what we actually will come to is the retention of all the bilateral relations agreements which we have now in place, as it is, as they are, a certain mechanism of interaction between the Commission and individual country member in curing the inconsistencies, if there are any, in bilateral agreements, would be, say, found or established, but on the other hand, the right to enter into new investment agreements would be reserved by the European Union, and the key negotiations, of course, would be negotiations with China, if China agrees to enter into such negotiations, and with the Russian Federation, definitely. As far as Russia is concerned, I will continue with the subject matter. Our authorities, our business community, and more particular oil and gas companies, are not interested in, say, to be involved in such negotiations, because bilateral agreements are in place between Russia and practically all EU member states, and were protected in the Baltic states and in other EU countries against any, say, wrongdoings which is done against our companies, our interests. So to enter into a new process which would say enhance better or more strict protection of the Russian Federation investments is not of interest. But there is always room for negotiations. There is always room for sort of a bargaining, I would say, and the situation will be developed. But drawing the line under the subject matter of the investment legislation reforms, it's still under review, and I think it's very interesting discussion is going on as to how the new agreement would look like. What will be the principles upon which they would be based? This discussion is still actively going in the European Parliament. It's far from being over. Well, we have indeed the situation, to the best of my knowledge, in Russia. They can be proposed within the, say, negotiation process, because the principle of pacta sunt servanda has not been repealed so far. But it is European internal law is such that each member state should rectify such agreements, which is in conflict with the international law. But from the standpoint of the international law, the internal European law should not be contradictory with international law. But the actual way out, the real way out, can be found only by way of bilateral, say, discussions, because unilateral change of provisions of international treaty is unthinkable. Under the law of international treaty, this is unthinkable. Russia is not willing. Well, additional question: if Russia would want to enter into amendments to its bilateral treaty with the Germany about investment process, whom they should be talking to? With the government of Germany, or now should they go to the European Commission? Well, the German agreement is fine. There is no inconsistency with the European law as far as the Russian-German agreement is concerned. But while there are issues with Austria and Sweden, then we will be speaking about those violations which inconsistent. They will be negotiations conducted on a bilateral basis. But any new agreements, which the idea is to enter into a framework, umbrella type of agreement at the level of EU, which would apply to all 27 or 28 countries, and which would cover, which would introduce new disciplines as far as the protection of investments is concerned. And under the new agreement, negotiations, of course, will be conducted between the European Commission once it gets amended by the European Council and the Russian Federation. That will be the format of such negotiations. Well, an attempt was blocked to define a deadline. They are without term. Those agreements are without term. By and large, they do not have any, say, expiration date. Bilateral agreements on investment protections are without term of validity. They are for life, so to speak. So an idea was within the EU to define a deadline by which all such bilateral agreements would expire, but this was not accepted. They're going to be valid as long as they are under their own internal provisions.
Yes, if I just may comment on the international law and the European Commission role. In fact, the European Commission negotiate international agreements once the European Commission got a mandate from the European Council. And once he got a mandate from the European Council to negotiate an international agreement, member states cannot negotiate any more bilateral agreements which deal with the same issue. But before the Commission gets such a mandate, then member states can still negotiate bilateral agreements if it is in conformity with the treaty. And this is the whole question of this bilateral investment agreement, whether you can still negotiate bilaterally once the Commission got the competence. But the existing agreement, the one we was negotiated before the entry into force of the Lisbon Treaty, they are in force and they will continue to be in force unless there is a new umbrella agreement which replaces them. But until there is such an umbrella agreement, they will continue to remain into force. I hope it clarifies the situation.
If there are no questions from the floor, I would like to ask one more question to Mr. Said about the common currency, about the expediency of introduction of the single currency not only within the framework of the single European economics, but I would like to hear your opinion on the situation which we currently we're seeing in the European country with euro, and it looks that the decision in respect of those parameters which are necessary to be adopted in respect of the fiscal discipline, about the interest rates, etc., are presently is not likely to be found easily or soon, because there are too many participants working with euro currency, and there are too many conflicting interests. And well, it appears that the reformatting or disintegration of the eurozone is likely. So, considering the probability of such scenario, do you think it is expedient to think to go into implementing a similar initiative within the Eurasian economic community? What do you think?
Thank you. It's a very interesting but extremely difficult question. I can answer this from the legal perspective. I'm not an economist. Now, this idea of having the single currency, this came out, as I said, after the Maastricht Treaty, 1993. It was not there before. And the Maastricht Treaty put very strict conditions for a country to adopt the euro. Now, just because one country joins the European Union, it doesn't have the automatic right to adopt the euro. There are strict conditions. Now, in 1999, there were 15 member states who were in the European Union. And there are what is called the 4 convergence criteria, so-called on inflation, interest rate, fiscal rules. It's about the budget deficit and the debts, and also the stability of the national currencies. Now, this became highly a political project. So there were 2 institutions which had to make a decision, which are the member states which should join the euro and which should be kept out. Now, when I wrote an article soon after this decision was made, there were about 3 member states which was kept out of the euro project. Countries like France, Germany, they are big, powerful countries. They came in. From my interpretation of the legal rules, even they disqualified. They were not strictly qualified to adopt the single currency. For example, the European law says the debt of a country should not be more than 60% of its gross domestic product. Now, Germany, the economic superpower, without Germany there will be no euro. Germany did not fulfill the requirement. Then, on the other hand, we had countries like France, politically indispensable to have this single currency. Now, before France joined, it was far behind when it comes to the deficit. It had a huge deficit. What the French government did was they privatized one of the big telecom companies, the French Telecom, just the particular year which was to be the deciding year for France to join or not. Now, by privatizing, France managed to fulfill this criteria. They came in. And then what happened with Greece was, in the first round, Greece completely failed all the requirements. So it was kept out. Within 1 year, Greece fulfilled all the requirements that they joined. Subsequently, the Commission detected that the Greece came out with false figures. But the problem we have is even now, once a country joined the single currency, and if it is found subsequently that some countries have cheated on the system, there is no legal mechanism to kick out that country. Now, this is a situation with Greece. Now, European Union is caught in a real legal crisis now. It's not only the fiscal crisis, but also from a legal crisis. Because Greece is becoming a burden all the time, and this is having an impact not only on the Euro countries, even in countries like Sweden. Because of the Greek crisis, the support for the Euro has dropped to the rock bottom. So this is a very big problem, because Lisbon Treaty, as my colleague said, it brought huge changes. One was that earlier there was a legal vacuum. That is, if a member state is not satisfied with the European Union, there was no legal mechanism to get out. Now this was rectified. Now what the Lisbon Treaty says is, if a member state wants to leave the European Union, they can do that. But there is no provision for a member state to leave one of the policy areas like the monetary union. So this is a situation which I think is now facing the European Union. Then the lesson that could be learned from what we have about the single currency in the European Union, to the question you raised from the Eurasian Economic Community, I don't, of course, discourage this, because the EU has benefited enormously, I think, in terms of trade with having the single currency. The problem is that, from a legal perspective, this legal, the foundation of the euro is what I call it as a half-baked project. They created a monetary union with the EU having the full competence to decide. You have the European Central Bank in Frankfurt, one of the most powerful independent institutions. Then on the other hand, you have the other side of the euro coin, the fiscal policy, that was left to the member states of the European Union. So it is this clash between the monetary policy at the centralized level and the fiscal competence at the national level that has created this problem. The problem with Greece was, once it joined the euro area, by virtue of its membership having this euro, the financial markets across the world just gave out loans as much as they want without any guarantee, because it was backed by the euro. So what Greece did was, without producing, they kept on borrowing and spending. They didn't do much to raise the taxes and develop the economy. So now what the European Union is trying to do is to come with a new treaty called the Fiscal Treaty to curtail the powers of the member states in the field of fiscal policy. Now, under the European law, if any changes has to be made to the Lisbon Treaty, it has to be done unanimously. Now, this matter came up before the European Council, where the heads of states meet. United Kingdom said they will veto that if they are not getting any concessions. So that means the Lisbon Treaty cannot be amended to bring fiscal union. So what they have resorted is to go into an intergovernmental agreement. This treaty is to be done outside the framework of the European law. So most probably, I think this fiscal treaty will come into force 1st of January 2013, because what has been agreed by the leaders of these EU countries is that there is no need for unanimity. If there is, I think, 12 member states, if I'm not mistaken, from the Eurozone, if they ratify this treaty on a fiscal compact, that will come into force. Now, if that comes into force, this will seriously limit the national competence in the field of fiscal policy. Every member state which sign up to the fiscal treaty, they will be required to amend their national constitution and to see that they don't have any serious excessive deficit. They have to say that the national law is compatible with the European law when it comes to the fiscal deficit. And if that is to happen, I think the member states will, to a great extent, lose or have to transfer their competence in fiscal policy to the European Union. Now, as far as the EU experience to the Eurasian Economic Community, I would prescribe the EU experience which was launched in 1979, which is called the European Monetary System. Now, under this mechanism, the national currencies of the European Union member states, it was pegged to a kind of a system called the European exchange rate mechanism. Competence was left with at the national level, but the central banks work very closely with each other to see that there is close cooperation in the field of monetary policy without any binding legal requirements. So this, I think, could be done, for example, between Russia, Belarus, Kazakhstan, where the central banks, I think, they have a lot of cooperation. They can further strengthen this cooperation. I was very sad to see that As I said, I've been in Belarus quite a lot. Yesterday, I went to 4 or 5 banks in the center of St. Petersburg. I was trying to change my Belarus money into Russian rubles. Not a single bank accepted that. Now, this mentality has to be changed, I think, because European Union, we had the currencies that could be freely changed in all the countries. So these are areas I think Eurasian countries can learn from the EU model and should try to avoid the mistakes which has been done in this process. Thank you.
Yes, I just want to add a comment on one of the lessons and the mistakes that we have done in the EU, which are useful for EurAsEC. And I think what my colleague said is we have done some mistakes, and I'm not talking officially here, but one of the things that for EurAsEC is important to take into account is that the fact you have to have mechanism to go backwards if something goes wrongly. And I think that was one of the mistakes at the EU, because we have no possibility to go out of the euro. It was not foreseen that a country joins the euro and one day has to go out of the euro. That was one of the problems. We have no possibility to put one member state out of Schengen, and if this member state is not controlling properly its external borders with third countries, they should go out of Schengen, because the external border of Greece with Turkey is in fact the border between France and Germany, because there's no internal border. So when Greece is not controlling properly the border with Turkey, it means that the whole system collapses. So there is no mechanism of sanctions to go backwards if a country is not fulfilling its task in the euro, in Schengen, and in many other areas. And there's no possibility to go out of the EU, of the European Union. We didn't plan a way out. If a country like there's a coup d'etat and a country is going very badly, they're still member of the EU. There's no process to put a country out. There is a European Court of Justice, sanctions level, and so on. But there is no process to go out. And that's something that you have to think when you are further developing EurAsEC, proper mechanism. And of course, it's also risky, because it gives a possibility for a country to go out for populist reason at any time. So you have to define the proper legal mechanism. There has to be clear criteria to go out. But it needs to be done if you develop a single currency, if you develop a common border system, if you develop a fiscal union, and so on. You need to foresee this type of mechanism. And that's what we are clearly doing right now. In the Schengen area, we are now developing rules to put a country aside if there's a problem with its border. With the euro, we'll see what we are going to end up, but we are on this trend. So you have to look at our mistakes as well, not only at our success.
Thank you very much. If no questions, I would like to present my last statement, and I will speak on the possible agreement in the free trade zone and the relations between EU and EurAsEC. So this is the title of my presentation: EU and EurAsEC along the path to the zone of free trade. Well, this idea will greatly benefit both to manufacturers, economy of Russia, Kazakhstan, and Belarus, and the European Union. But on the other hand, there will be certain barriers along the path towards the achievement of such an agreement. And this idea already exists, and apparently you know that during the last day as the Prime Minister, then Vladimir Putin mentioned certain changes that should be introduced into the customs policy. Now the question is how this task should be translated into life. If we characterize the situation in general and the status of the relations between the European Union and Russia, Russia wages talks with the European Union for quite a long time. So this could be illustrated by this slide, and I will now give you explanation using the next slide. If we take the trade balance between the European Union and Russia, yes, in U.S., in relations with U.S. and Russia, there's some negative effect of the mutual trade. For instance, the import into the European Union is bigger than the export of EU goods to Russia. But still, this balance will be negative, and in the nearest future, this situation will not change. If we take the structure of export from Russia to the European Union and then from the European Union to Russia, then the situation is as this. We export at present mainly oil and gas, 80% of our export. The rest are the raw materials. These are the products of ferrous and non-ferrous metallurgy, rolled steel, etc. And these are materials which do not use the highest price, because we export mainly oil in the European Union. 50% of export tools, machines, what is delivered from the EU to St. Petersburg by railway. Here, the deficit trade balance is in favor of the Russian Federation. And we, as all countries of the European zone, as well as China, try to be in the industry of high added cost and move in the same direction with the advanced countries. Well, going back to the first slide, the situation at present from the point of view of trade and economic relations is as follows. We export gas, oil. We have certain assets and we try to expand these assets. But the most interesting thing is that this situation is also to the liking of the European Union. But on the other hand, they are interested in the pipe and where it goes from, because they want to protect their interests in the Russian market. This is the initial situation from the point of view of the economy. If we take the privileges and benefits, what we would like to get as the country, then in the forthcoming negotiations, we will face standard things such as bilateral reduction of import taxes or import fees, which will be in the format of the European Union and the EurAsEC. And this benefit will be rather great. For instance, if Russia enters WTO and Kazakhstan will also become a member of the WTO, then in zeroing import taxes for our import products, $1 billion will be in the pocket of the Russian companies, such as products of petrochemistry, of fertilizers, etc., where we have quite an essential tariff of 3.6% with regards to chemistry. In other words, here it will be, we will be interested in continuing these negotiations, and the EU is also interested, because even after Russia becomes a member of the WTO and Kazakhstan as well, we shall have the export tariff at the level of 7%. In other words, the perspectives in taxes exist And this will be of interest both for the Russian and the Kazakh business. As far as agricultural products, and about 10% of export is agricultural produce, and we, both Kazakhstan and Russia, and naturally Belarus, from the point of view of the access to the agriculture market, because this is the most profitable market in Europe, we do not see our presence there. Well, we have leading positions on grain, beef, and milk, and no doubt we discussing at present or hold negotiations on the expansion of quotas. And there's another very interesting subject. If we manage to strike an agreement on liberalization with trade and services, then no doubt that will be a great breakthrough in bilateral relations than the ones that we have with regards to the commodity products. And no doubt for Kazakhstan and Russia, we will have more privileges in banking structures, but on the other hand, for the Europeans, they will have the priority of an access and full control over suppliers of services in the Russian Federation, in the banking, insurance, and the market of assets. Here, from the point of view of benefits, the figures of increasing these figures will be by an order higher than in realizing the commodity market. At present, the EU also hold negotiations on creating free economic zones on the conditions of creating a comprehensive agreement on all those positions which are of interest for the European Union. First of all, full harmonization of technical standards and sanitary control and mutual recognition of those documents which each country uses. For regulation of these issues, then state purchases. Well, the EU insists during all negotiations on the investment approach to the state purchases. And once again, going back to the pipe, first of all, is the problem of protecting investments and the problems related to investments into the production of energy. And you know that there were problems also, there were issues on insurance companies and many other companies of this type. From the point of investments, from the point of Russia and Kazakhstan, well, there are certain problems. And Gazprom also now faces a situation where it would like to have certain priorities, but we are interested in entering commodity markets. And for the Europeans, the biggest problem will be protection of their investments. And what is the present stage of negotiations? As you know, both Russia and Kazakhstan signed an agreement with the European Union on cooperation and the basic instruments. For instance, the Russian agreement was signed in 1994, and the basic principles were introduced into those agreements. The interaction on both commodities and services, but both sides also carry out negotiations on reforming these agreements, making them more comprehensive. And from this point of view, we launched agreements on two agreements in 2008. We began negotiations knowing that we at present are working with Kazakhstan, working at the agreement on partnership and cooperation. These negotiations were terminated, and at present they are not being held. Well, formally there are no meeting. Well, there are meetings between negotiators. Well, Mr. Yezhov were unable to be present at our forum. But in fact, while we have the fundamental difference in the positions of the parties, how this agreement should look and what should be reflected in it, well, at present, Russia joining the WTO will give a new impetus to this subject. And the essence of our position was that we shall not wage any negotiations before that we enter WTO. First, well, we thought that first of all we have to enter WTO and then discuss additional issues. At present, we refused to carry out these negotiations, and here I enumerated the discrepancies in negotiations between the EU and Russia, because EU insists on the issues of joining WTO and on tariffs in our relations, which is not acceptable at present for Russia due to the reduction of the tariff reduction as a result of entering WTO. Well, at present, we suggest that this issue should be discussed in a certain agreement, and it should be discussed in several years. Well, the same issue concerns also energy, due to the fact that Russia is not interested in dealing with this issue at present. But in principle, these are the issues that are present in negotiations. There's the difference, as always, in the positions of the parties on what should be included into these agreements, but these problems could be addressed. Well, until recently, the key problem was the problem of the format of such an agreement at present, due to the fact that the customs union is already in full swing, and there's a whole number of agreements which lay the fundamental basis for the negotiations. And such negotiations should not have negotiations with the European Union, because we do not have any agreement on customs tariffs with the European Union. Well, although in principle these negotiations are held with the European Free Trade Zone, but it is quite natural for Europe to begin negotiations formally in the economic zone. There's the political problem, the problem of Belarus. And there's also the problem of synchronization of bilateral negotiations with EU with regards to us entering WTO. Well, we have to understand where the customs unions be after we join WTO, and to say the least of Kazakhstan. And in this connection, it will be difficult to launch concrete talks on creating the zone of free trade. And I think that when Kazakhstan joins WTO, which will happen in the nearest future, then no doubt we shall have a single customs tariff, which will be constant for a very long period of time. And it can be taken as the basis for the negotiations. And once again, in conclusion, I would like to remind you that the potential for all these issues, for solving all these issues, is quite big. And this will give us certain privileges as compared to China. And it will also give certain privileges for Russia, Kazakhstan, and Belarus, since no doubt it will help the investments that will be made into our countries. And these talks, if they start, then no doubt they will be extremely sophisticated and difficult, due to many reasons. Well, unfortunately, we don't have Mr. Glazer with us, because he could give some evidence to it. But you know probably that the agreements on the free trade zone is always concluded on unequal conditions. There's the country that imposes its conditions on another country. And For instance, we have an agreement between Russia and Ukraine where we didn't have any negotiations. We imposed our conditions on the Ukraine, and they, according to political considerations and being interested in it, accepted it. Well, having agreed with the conditions of supply of agricultural produce, but at the same time, they eased certain conditions for the delivery of automobile products to our country. No doubt we shall have these negotiations, but unfortunately they will go on for quite a long period of time. But once again, I would like to emphasize, as a person who works with Russian business and international business as well on the territory of the customs union, I think that the situation is quite perspective, because we have the opportunity of discussing the issues not only of exchange of commodity products, but also the issue of investments. And I think that in the near future, these problems will be addressed. Well, the transition period, much will depend on the transition period. Well, for Kazakhstan on different positions. Russia, for instance, enters the adaptation period that will terminate in 2017 on the majority of positions. But we do not know whether there will be a critical situation in Russia. For instance, if we will still have the automobile industry or will liquidate this all. Well, we have to study the situation and see whether we can do it. But much will depend on the position of Kazakhstan in its transition period. Well, I have the following questions. An American analyst, Friedman, in his book, The Forthcoming Decade, emphasizes there were three outstanding presidents in the United States. Abraham Lincoln, because he managed to preserve the Republican system of management, then Roosevelt for conquering the world ocean, for free trade economic zone, and Ronald Reagan for decomposing the Soviet Union. Well, on the basis in this way it increased the purchasing capacity of a dollar and reduced prices for oil and gas. Since that time, and from that time on, in the import and export balance, nothing has changed. Well, there were no essential changes there. Russia and Kazakhstan remain the states which export to Europe and other countries of export energy resources. I wonder that it may happen as a result of for these countries entering WTO and further integration of the economy into the European zone. Won't it lead to the situation that in some time not the American but the European analyst will write or will draw similar conclusions?
Well, it's a difficult question, of course. This is debated every day in our parliament, in the State Duma, 24 hours a day. 7 days a week about the advantages of accessing the WTO and deficiencies and negative upside and downside actually of our accession. So I can give you a dual answer, a double-decker answer, if you will. To participate, to access to WTO is something we should do, because China serves a good example. They accessed in the year 2000 and they increased the export by a factor of 7, and every 5-year say period they are going more and more into the value-added exports. So by referring to the Chinese example, and we come to the second part of my answer, a lot will depend on the Eurasian Economic Commission as to how we're going to, what kind of industrial policy we're going to pursue. Well, we should identify priorities for our industries and to work towards achieving those say priorities, because it is not possible for us to provide finance to all say industries across the board. We have to focus our resources on specific projects and given guarantees and through participation in the multilateral trading system, which would provide us a predictable and assured access to foreign markets, and by say through appearance of the competitive manufacturer in Kazakhstan, Belarus and Russia, we can come to a situation when our dependency on the export of gas and oil will become less and less. But this is something which is debated. So to pursue industrial policy, being a member of WTO will be a difficult thing to do, because we assume obligations on importation and exportation duties. Since those duties will be going down, there are things which will complicate pursuance of dedicated industrial policy. But on the other hand, the competition will increase, and that will enhance the say economics, and we'll have greater predictability as to where we can be present and what market we can be. So I cannot give you, say, precise and clearly cut answer. That will depend a lot on the policy, industrial policy, which to be pursued by our new leaders, both individually and within the European and Asian Economic Community. If we do nothing, if we do not draw 5-year economic plans and meet the targets we define, then our accession to WTO will be disastrous. So looking at the conditions of our accession to WTO, we can clearly see those industries which are doomed to die. They will not be able to compete with China, for example. So a new economic policy, new industrial policy has to be put in place to enable us to reap the benefits from accession to the WTO rather than to suffer from these new developments. Thank you. Colleagues, I think we have exhausted our agenda. I want to thank on your behalf our speakers. Thank you very much indeed for the time that you have spent staying with us for a very interesting discussion in which you participated, and I wish luck to all of you despite gloomy overcast today. Thank you.